Have you ever heard the saying, pride comes before a fall? Today we re-diving into a real-life courtroom drama where one lawyer, a staggering arrogance, completely flipped the script on a major trial. This isn't a movie. This is what happens when ego gets in the way of justice. The case revolved around a complex corporate fraud accusation. On one side, we had a team of prosecutors who had spent months, even years, building their case brick by brick. They had documents, witness testimonies, and what they believed was a slam-dunk argument. On the other side was a legendary defense attorney. Let's call him Mr. Vance. Vance was famous not just for his win record, but for his flashy style, his sharp suits, and an air of complete invincibility. He'd walk into a courtroom like he owned it. And honestly, he often did. His reputation preceded him, and many believed if anyone could get an acquittal in this seemingly impossible case, it was him. The trial began as expected. The prosecution laid out their evidence methodically. It was dense, full of financial jargon and complicated transactions. But the narrative was clear. The defendants had knowingly deceived investors out of millions. The jury looked focused, maybe a little overwhelmed, but they were following along. Then, it was Mr. Vance's turn. He didn't just cross-examine the prosecution's star witness, an insider who had turned whistleblower. He tried to annihilate him. Vance was sarcastic, condescending, and relentless. He questioned the witness's memory, his motives, his character, everything. He'd ask rapid-fire questions, cut the witness off, and roll his eyes at the answers. His goal was obvious: to paint the whistleblower as an unreliable, disgruntled employee looking for revenge. To a certain extent, it seemed to be working. The jury saw a powerful, confident lawyer dismantling a nervous man on the stand. The prosecution's case wasn't just about this one witness, though. A huge part of it rested on a mountain of digital evidence, thousands of emails and internal memos. The prosecution had their own expert explain how they had recovered these files, authenticating them and linking them directly to the defendants. It was tedious but crucial. This is where Mr. Vance decided to show everyone just how brilliant he was. During his cross-examination of the prosecution's digital forensics expert, he wanted to prove that this so-called evidence could have been tampered with or was uninsecure, as the expert claimed. He started with a series of basic, almost patronizing questions about file storage and server security. The expert answered calmly and professionally. Feeling confident, Vance decided to go for a big, theatrical moment. He strode towards the witness stand, holding a thick binder of documents. "So," he began, his voice dripping with condescension, "you claim these emails are a perfect, untouchable record of my client's communications. Is that right?" The expert simply replied. "They are an accurate copy of the files recovered from the server." Vance smirked. "An accurate copy. But you weren't there when every single email was written, were you? You can't possibly know the context of every single message." The expert agreed. That wasn't his job. His job was to verify the data's integrity. And then, the fatal mistake. Vance, in a moment of pure hubris, decided to use a specific exhibit to make his point. He wanted to show that an email could be misinterpreted or was just one tiny, irrelevant piece of a much bigger puzzle. He opened his binder and pointed to a specific email, Exhibit 114B. "Let's look at this email," Vance announced to the court. "The prosecution wants you to believe this is some kind of smoking gun. But it's just a simple scheduling query, isn't it?" He handed the document to the expert. "Read the first line for the jury, please." The expert took the paper, glanced at it, and then looked at the prosecutor. Strange, almost imperceptible shift happened in the room. The lead prosecutor, who had been looking down at his notes, suddenly sat bolt upright. His eyes widened. He looked at his co-counsel, who looked just as stunned. The expert cleared his throat and read, "As per our conversation. Let's proceed with the alternative accounting strategy for the quarterly report." Silence. Complete and utter silence fell over the courtroom. You could hear a pin drop. The jury, who had been lulled by the technical jargon, was now wide awake, every single one of them staring at Mr. Vance. Vance's smug expression evaporated. His face went pale. He snatched the paper back, his hands trembling slightly. Just in front of everyone, highlighted the single most damning piece of evidence in the entire case. An email that the prosecution had, for strategic reasons, decided not to emphasize just yet. They were planning to build up to it, to present it later with maximum impact. But Vance, in his arrogant attempt to show off, had done their job for them. He had gift-trapped the prosecution's smoking gun and personally handed it to the jury. He had authenticated it with his own question and had the expert read the incriminating line aloud. The phrase alternative accounting was a clear, undeniable euphemism for cooking the books. The prosecutor couldn't believe his luck. He stood up slowly. No further questions for this witness, Your Honor. He didn't need to say anything else. Mr. Vance had just imploded his own case. The rest of the trial was just a formality. The defense was in shambles. The confidence and swagger were gone, replaced by a desperate, fumbling attempt at damage control. But it was too late. The jury had heard it. They had seen the lawyer's own shock and horror. The phrase alternative accounting hung in the air for the rest of the proceedings. When the jury came back with their verdict, it was no surprise. Guilty on all counts. As the defendants were led away, Mr. Vance stood there, completely defeated. The man who walked in like he owned the world now looked like he wanted it to swallow him whole. This story is a powerful reminder that in a courtroom, and in life, overconfidence can be your greatest enemy. Mr. Vance was so focused on his own performance, on his reputation as a shark, that he lost sight of the most important thing, the facts of the case. He thought he was playing chess, but he ended up knocking over his own king. Just goes to show you, sometimes the biggest blow in a fight comes from your own hand. What do you think? Is this the worst lawyer mistake you've ever heard of? Let me know your thoughts in the comments below. And if you enjoy stories about justice and courtroom drama, make sure to hit that like button and subscribe for more. Thanks for watching.